founding failure when it comes to race and equality in this country, and reckoning with our past to create a more just future. So if you don't already, we encourage you to follow ACS on social media, including on Twitter at ACS Law. You can also find us online at acslaw.org. There you can join ACS and find more information about upcoming events and opportunities. Less than 2 weeks ago, the U.S. military completed its withdrawal from Afghanistan. As we reflect on that chaotic end to America's longest war, we also reflect on all that has changed, both at home and abroad, in the 20 years since the September 11th terrorist attacks took the lives of 2,977 people at the World Trade Center, the Pentagon, and in Somerset County, Pennsylvania. Those attacks shattered the sense of innocence that Americans lived under and fundamentally reshaped American life as our governing institutions were reorientated to deal with the threat of international terrorism. The legal legacy of those governing decisions is something that ACS is exploring this month on its blog, in its publications, and in its podcast, Broken Law, as part of our commemoration of the 20th anniversary of the September 11th attacks. For today's program, however, Indefinite Detention, Examining Guantanamo 20 years after 9/11, we're going to focus on one particular aspect of that legacy, the decision to operate a military prison at Guantanamo Bay. Today's panel is going to look at the past, present, and future of Guantanamo to help answer the question of what is going to happen to the 39 men still detained at Guantanamo almost 20 years after 9/11. We have an incredible panel of experts with us today. So to get the conversation started, I will turn it over to today's moderator, Linda Greenhouse. Linda is a clinical lecturer in law and senior research scholar in law at Yale Law School. Previously, Linda covered the Supreme Court for the New York Times, of course, and today she writes a biweekly op-ed column on the law as a contributing columnist. Linda has received several major journalism awards during her 40-year career at the Times, including the Pulitzer Prize. A prolific author, Linda is one of the only two non-lawyer members of the American Law Institute. And perhaps most importantly, for our purposes, she is also a member of the ACS Board of Advisors. So we're very proud to call her a friend. Linda?
Thank you very much, Russ. As Russ said, our charge is the past, present, and future of Guantanamo, but I'll just speak briefly about the past because we have real experts. Okay. As I was going to say, we're going to focus on the present and the future of Guantanamo, but I'll just say a few words about the past. Of course, 20 years, shortly after 9/11, two important decisions were made by the Bush administration. One was to establish a legal black hole at Guantanamo Bay at the U.S. Naval Base there. The idea being, from the advice by John Yoo and some other people whose names you might remember from that period, if we put the detainees, people captured or bought from bounty hunters on the fields of Afghanistan and Pakistan, if we put them in a place, quote, outside the jurisdiction of the federal courts, nobody could touch them and it wouldn't matter what we did with them. That was the idea behind Guantanamo. The second decision that was made very shortly and very surprisingly after 9/11 was to set up a system of military commissions that would try detainees who would ultimately be charged with crimes outside the domain of the federal courts. And I think we'll talk about the aftermath of both of those decisions. But I'll talk a little bit about what happened after Guantanamo was set up. I'll never forget reading a petition for certiorari that came in the fall of, I guess it was 2002, a case called Rasul. Nobody had ever expected the Supreme Court to get involved in this matter because as John Yoo and the others had advised the Bush administration, the federal courts were not going to have anything to say about this black hole that had been set up. Attached to the cert petition were a few amicus briefs, and one was filed in the name of Fred Korematsu. So we all remember the Korematsu decision, to the shame of the Supreme Court, that upheld the detention, the rounding up and detention of 100,000 or more Japanese American US citizens, the Korematsu case. And Fred Korematsu, then, he's no longer alive, but he was alive then. And Professor Jeff Stone at University of Chicago and some others filed on his behalf an amicus brief in which he basically said to the Supreme Court, you made a terrible mistake in my case. And guess what? I'm still here. And I'm here to beg you, don't make that same mistake again. Pay attention to what's going on in Guantanamo. Take it within your jurisdiction. And to the shock of almost everybody, and I actually give a lot of credit to that amicus brief, the court granted cert and became involved in the Guantanamo situation and decided that indeed Guantanamo was within the jurisdiction of the federal courts, first as a matter of statutory interpretation of the habeas statute, and eventually in the Boumediene case in 2008, under the constitutional jurisdiction of the federal courts by interpreting the suspension clause. In between those two events, Congress tried its best to strip the court of jurisdiction. There was a fascinating back and forth between Congress and the president on the one hand and the Rehnquist court on the other hand. It was a very surprising set of outcomes, but the court really stood for the rule of law at that period. What happened? Well, after Boumediene, a lot of habeas petitions came to the federal district courts in DC, and many of those were successful in the sense that there were something like 53, with the number I saw, habeas petitions that reached federal district judges at that time. And of those, some 70% of habeas petitions were granted. But the DC Circuit had something else in mind. The DC Circuit, there was a senior judge there named Judge Raymond Randolph and some others who really thought Boumediene was a terrible, completely wrong-headed decision, and they did their best to block it from having any effect. And so within a very short time, the habeas train came to a stop. Those district court decisions that had not reached final judgment were reversed by the DC Circuit. And since about 2009, there have been no new contested habeas cases that have reached final judgment. So we hit a wall, and the future of Guantanamo was, at least in my view, taken out of the federal courts and remitted to the political process. And we all remember that President Obama came in 2009 vowing to close Guantanamo. That did not happen for political reasons. He didn't have or chose not to try to spend the political capital to do that. And we are where we are today. So our plan for this hour, I apologize again for the mix-up at the top of it, is to call on the expertise of our panel to have really a conversation, not a series of set pieces. So I'll introduce them briefly, and then we'll start, I think, where Russ Feingold suggested that we start, this amazing fact that we're now out of Guantanamo, out of our longest war. And I'd be interested in hearing people talk about what can this possibly mean for the continued detention of 39 individuals, the great majority of them never been charged with a crime, who have gotten old and sick, and some of them mentally ill, while sitting in Guantanamo for close to 20 years. Joining us, I'll just mention them all at once, and then we can all start to talk, I hope not all at once. Bahir Azmi is the legal director of the Center for Constitutional Rights, where Guantanamo is in his portfolio. He's also a law professor at Seton Hall. Hina Shamsi is director of the ACLU's National Security Project, and she's also lecturer in law at Columbia. She's monitored the military commissions, and I'm sure we'll have a good deal to say about those. Rita Simeon is senior counsel to the Senate Judiciary Committee, and Guantanamo is also within her portfolio. And Steve Laddick is the master of all facts and figures about Guantanamo for these many years. I think there's nothing that's ever happened there that has escaped Steve's notice. So I'll throw this out to all of you, and then maybe I'll drill down and call on your specific expertise. But how do we even think about the situation now that the war is over, the AUMF, the authorization for the use of military force is kind of hanging there. I don't even know what its status is right now. How do we respond? How do we even think about the situation that we find ourselves in 20 years later? Everybody has to unmute. I see you're all muted. Steve, do you want to start us off?
Oh, sure. I was hoping that someone smarter would go, but I guess I'll go first so they can correct me. So, you know, I guess where I start, Linda, is with the symmetry or the deep asymmetry between the approaching 20th anniversary of the 9/11 attacks and this week's proceedings in the 9/11 trial, which, you know, I think Hannah might have the dates better than I do, but I think these were the first proceedings in the 9/11 trials since before the beginning of the COVID pandemic, a number of days that runs into the high 500s, before yet another judge who's at least the sixth or seventh to preside over this trial in the last 4 or 5 years, at a stage of pretrial litigation that is impossible to understand without having gone through this rich history, why we're still here. And so I guess, you know, there are so many things to say about the last 20 years and how we got here and the mistakes that were made and the quagmire that we're still in. I am just struck by the profound lack of closure. And, you know, and closure for everybody, closure for the victims, closure for their families, closure for lawyers who signed on to some of these cases in 2002, 2003, thinking that it would be an important but short-term project, and for whom it's become a career. And I guess it's just, you know, it is mind-boggling to try to describe the comprehensive complexities and idiosyncrasies that have been the last 20 years, the amount of money that the United States has spent on this program, the amount of law that has been generated, the amount of man hours that have been expended by people on all sides, and how remarkably little progress we have made in any measurable direction from where we were, you know, certainly in 2009, and I would say even at various points along the way before then. So that's not to say there hasn't been progress, but it's just, if you had told me, you know, I don't know, in September of 2002 on the first anniversary of 9/11, that this is where we'd be on the 20th anniversary, I would have bet the house the other way. And I think that's, you know, to me, that's the most profound and saddening thing about where we are, is just how much we haven't made any progress in any direction, even if we might disagree on which directions are the right ones.
Well, in fact, the hearing that you mentioned the other day ended in disarray, didn't it? As like some new obstacle came up.
Well, but this, I mean, and you know, for folks who follow the commissions even more closely than I do, I mean, this is par for the course. And you know, I guess the area that I probably track the most obsessively is how all of the Guantanamo stuff has fared when it's been subjected to the daylight of judicial review. And it's fared terribly, even with, you know, pretty sympathetic DC Circuit rulings in 2009, 2010, 2011 on detention. It fared terribly on the habeas side, where still half of the detainees who had habeas petitions litigated all the way to a final judgment prevailed. And that was the detainees who were still at Guantanamo in 2009. And the military commission's track record has been even worse, where the most recent significant Article 3 court ruling on the military commissions wiped away 2.5, 3 years of proceedings in the trial of the USS Cold Bomber because of a conflict of interest the trial judge had that would have been obvious to everybody except apparently the trial judge and the government. And so it's just, you know, wherever you turn, Linda, you see this. You see complexities, you see mistakes, you see, you know, procedural mishigas, you see torture and the ever-present shadow of what the CIA did to so many of these detainees. And I guess it's overwhelming which is part of why I think it's so important for us to have this conversation and why other people should weigh in.
Right, please do. Hannah, you have followed the commissions, right? Is there an end in sight? And if not, what's the point?
I think what's the point is a very good place to start, Linda. Although I will say, I was just so moved when you were talking about Fred Korematsu, because I know it sounds incredibly dorky, but I reread that amicus brief every year on Fred Korematsu Day. It was just such a statement of courage at the time. And part of that is because it was a statement of courage at a time where our military and political leaders were not actually showing a lot of courage in terms of how to address and meet an act of violence with justice we could stand behind, accountability, meaningfulness. And I know we're going to get to the question of Afghanistan, but I think it's really important when we're thinking about the military commissions to add on to what Steve has said by saying, you know, for what? And is this something that we can be proud of? Because I think the one certainty right now is that the military commission system is broken, and that it is bedeviled by the use of torture. The 10 people currently facing charges in the military commissions were all subjected to torture and black site detention by the CIA. And the extent to which torture evidence can and cannot come in is a huge part of what is at stake in the military commissions, together with the secrecy. I think another thing, just to take us back and situate us, is that, you know, this is the kind of, I guess, second most or third, depending on how you look at it, iteration of the military commissions, right, under the Military Commissions Act of 2009. And so much still is unclear under that act. Steve rightly said that when, you know, these cases, military commission cases, reach the federal courts and are subjected to scrutiny, a lot of it gets thrown out. So among the things that I think it's really important to situate this in is that the MCA of 2009 asserts jurisdiction over offenses that are not recognized as international war crimes, or that predate the September 11 attacks, or that are unconnected to the September 11th attacks. They allow for civilians to be prosecuted before a military tribunal. The MCA limited the admission of coerced and hearsay evidence, but we see it still coming in the al-Nashri case recently, and then also the way in which that has perverted the Majid Khan plea bargain that recently came out. So if we look at the numbers, and let me just briefly give us some numbers, I think there have been 9 convictions in the military commissions so far. 7 out of those were plea bargains. 3 of those were vacated in post-conviction appeals. Steve mentioned one of them, but, you know, Al-Balul, another one, did not actually put up a defense at trial. And critically, in terms of things that are unresolved, you know, the only charge that survived in that case failed, which is conspiracy. It's still unclear the underlying constitutional question of whether that's viable in the military commissions. And a lot of the charges are about conspiracy. I want to sort of close with this just in terms of an observation. The most, I think, you cannot think about Guantanamo and the military commissions without thinking about the impact on torture and how that can not be unraveled from what currently exists. So let me use the case of Majid Khan, who was the most recent person who entered into a plea deal. And I don't represent him. I'm saying this from the outside as a close observer, but from what appears pretty ineluctable in that case, the plea bargain was arrived at in large part because the prosecutors wanted to prevent the CIA from testifying about Majid Khan's, from being questioned about Majid Khan's torture in his sentencing proceeding, right? And so given that torture is an issue in every single one of the charged cases, given that if you're thinking about fairness, then that's part of what's bogging it down. If torture-derived evidence is not, the government's position is that it cannot come in at sentencing, how is this supposed to go forward? What path is there possibly other than to recognize that the system is broken, it's futile, and we need different ways out of it?
You know, listening to you and to Steve, it occurs to me that even though the Bush administration was not successful in creating a legal black hole in Guantanamo to the extent that the federal courts did exercise jurisdiction, it is a black hole in terms of the public's ability to follow what's been going on there. I mean, I thought I was following things and I had no idea that the issue of conspiracy was still unresolved. Let me throw in one more case and then bring the others in. This is not a commission case, but it's a detainee case. It's going to be argued on bank before the DC Circuit at the end of this month, the Al-Hela case, which poses the amazingly unresolved question of, does the due process clause apply at Guantanamo? A very conservative panel of the DC Circuit said, no, it does not. That decision was vacated. The case was taken on bank. And, you know, you mentioned that early on after 9/11, the our political leaders were tongue-tied and afraid to say very much. That still seems to be the case because the Biden administration, as I understand it, declined to come in on the side of a full due process application at Guantanamo. And at midnight, as the government's brief was due, kind of crumped and said, well, the answer to that question really doesn't matter because this individual has received all the due process to which he's entitled. This was a failure of nerve. It was a big fight within the administration, not very well explained to the public. And it's just a reminder of this still remains such a hot button issue among those who know enough to care about it.
But Linda, not just hot button, but like chaotically unresolved. I mean, you know, that Al-Hela is a great example, both of the fact that the due process issue isn't resolved and of the fact that even the DC Circuit still isn't going to resolve that much, right? Because when it went on bonk, the DC Circuit did not take the entire case. It just took the due process issue. And there's actually some pretty important substantive questions about the scope of the government's detention authority that are going to have to be resolved on remand. So, you know, 2 more years of this. And it's just, you multiply that by 39 detainees who are still at Guantanamo and by the hundreds who have been through Guantanamo, and you start to understand the enormity of the, you know, sort of the vacuum that has been, you know, forward movement in this space.
Bahir, let me bring you in from your perspective. I mean, is there a way out of this?
Yeah, I mean, you asked a really provocative question, but like, how should we think about Guantanamo, which sends some chills up my spine, and particularly when thinking about the possibility that detention authority might theoretically be limited following the pullout of Afghanistan. Footnote preview, I think, for preposterous reasons, it might not ultimately be because of the self-perpetuating and nature of what is, I think, effectively lawlessness in Guantanamo. And to the extent that we're talking about the persistent void and chaos, and I think Hina referred to this, that presumably stems from Guantanamo's original sin, which was to be created intentionally outside the jurisdiction of the US courts to exclude the possible constraints of law and lawyers in order to conduct sort of endless, brutal interrogations. So to try and overlay a system of law, which is a system of constraint and transparency, after years of incompetence, lies, secrecy, torture, is going to create friction. And the courts have not played the sort of imagined historic role around questions of torture and accountability and transparency, and has largely allowed the executive to continue to sort of muddle through. And we have a regime of ratified detentions in Guantanamo. So in this, I don't want to get too far into this question of whether or not the end of war in Afghanistan, I mean, in theory, particularly for those captured on or apprehended in Afghanistan, and I think there is one detainee, Harun Gul, who's making such an argument, the wind down of that authority should limit his detention. But of course, it's all made up. It's all lawless, and to be cynical, I mean, the government will claim we're still at war with Al Qaeda, if not just with the Taliban. So we can detain them for that purpose and forever. Should a new Al Qaeda spinoff, Alphabet Soup, open camp in Afghanistan, maybe that would in the future justify detention. I mean, I think in theory, Al-Hila, or the application of due process, which I agree should have been a no-brainer years ago. I mean, if the suspension clause applies extraterritorially to limit detentions, and given the connection between the suspension clause and due process, why wouldn't it also apply? And had it applied earlier, we've had more procedural due process protections. May there be a clear and convincing evidence standard instead of the negligence standard associated with a preponderance standard associated with a negligence case. But I mean, Steve's right, it will take a lot of time, but in theory, due process could do a lot of work. Due process suggests proportionality, due process suggests rationality, due process should suggest limitations on guilt by association. But having litigated some of these same questions for 15 years, I don't necessarily expect any dramatic results from the court.
Can I jump in here just to add to a little bit what Bahar was saying? So a couple of things jump out, which is just the basic idea. Why the hell in 2021 are we still arguing about whether fundamental fairness under the Constitution applies to Guantanamo detainees? I think that in itself is an indictment of the entire system. A second is that the government's position in Al-Hila, I guess if you're an incrementalist, which I'm not, was, oh, at least they didn't oppose it. So it's an advance. But what it also was of a piece of, with strategic litigation choices that seek to maintain expansive presidential and executive power, even when those choices undercut the larger goal. And what do I mean here? President Biden, like President Obama, and in fact, President Bush by the end of his presidency, wants to close Guantanamo. So why, as a strategic matter, is his administration undercutting that position by arguing against fundamental fairness when judicial processes would be a very good way of resolving indefinite detention cases? And also why in Mr. Al-Hila's case, given that he's been cleared for release as well?
Yeah, so let me bring Rita into this, because of course Congress has not been silent in this saga. If I'm not wrong, it was Congress during the Obama years that issued a rider on the DOD appropriations bill or whatever it was that prohibited the president from bringing the detainees for criminal trial on the continental United States, or for detention in the continental United States. Of course, criminal trial presupposes some charges, and the great majority of these individuals, other than the 10 commission defendants, as I understand it, have actually not been charged with a crime. But Is it even reasonable to think that there's going to be a congressional voice in the wind down? Maybe an amendment to the AUMF that would undercut the continued viability of Guantanamo, or how should we think about the role of Congress here?
Well, first, I wanted to react just a bit to what others have said. I was really struck as Steve and Hannah were speaking about the tremendous cost of Guantanamo. It has, as people have talked about already, it has cost the U.S. its reputation, its role as a leader on human rights and the rule of law, given the indefinite detention, the history of torture, et cetera. It has cost our ability to counter terrorism effectively. It has cost us the ability to achieve justice for the victims and families of 9/11. And the actual dollars cost is astronomical as well, right? We've spent $540 million in taxpayer dollars every year to maintain and operate the facility for 39 men who remain. So that's, if you do the math, $13.8 million per detainee per year. Which is pretty indefensible. So I think the 20th anniversary of 9/11 and of Guantanamo coming up in January, the withdrawal from Afghanistan, this moment really presents an opportunity to take a step back and to finally chart a new course here. I think the Al-Hila case that folks have mentioned is one such opportunity, but there are others as well. And my boss, Senator Durbin, has written both to President Biden and to the Department of Justice, urging reflection on this moment and a new course here going forward at this really pivotal moment. You raised the congressional restrictions that were put in place during the Obama administration by Congress. As you mentioned, there's a ban on transfers to the United States, including for criminal prosecution or for medical treatment. This U.S. transfer ban prevents us from being able to achieve justice. There are detainees who could only be prosecuted in an Article III courts because of many of the problems of the commissions that folks have been talking about. Also puts us at risk of reaching our obligations under the Geneva Conventions to provide medical care for prisoners in our custody. And there's just no legitimate basis for this restriction. We prosecute hundreds of terrorism cases very successfully, I think over 600 now since 9/11. We hold many hundreds of people for terrorism offenses securely in our federal prisons every day. There are also these very cumbersome notification and certification requirements, even for transfers to foreign countries. No such restrictions were in place when President Bush transferred hundreds and hundreds of detainees out of Guantanamo, and there's just no need for these onerous restrictions today. My boss again, Senator Durbin, has been very vocal in the need for Congress to lift these restrictions. But I want to be clear that even under current law, there's a lot that the Biden administration can do towards closing Guantanamo. There are a number of tools. Some of them have been mentioned already by folks today that are currently being underutilized, not being utilized at all, to actually get to closure on Guantanamo, taking advantage of the ability to negotiate pleas in federal court by video, for example, putting somebody actually in charge of Guantanamo closure at the State Department and at the White House. These are really critical steps that we haven't seen yet from the administration. So restrictions or not, there's a lot more that can be done. Folks have mentioned, especially Hannah, right, these positions that the Department of Justice has taken that really seem to be at odds with the president's goal of closing Guantanamo. It just doesn't make a lot of sense. So yes, the restrictions are problematic and should be lifted, but there is so much more that the administration can do even under existing law that just isn't being done right now. Linda, you also asked about the AUMF. So I imagine there are some folks who may not even know what we're talking about when we say AUMF, but after 9/11 attacks, for those who aren't familiar with the history, Congress passed an authorization for use of military force that gave the president the ability to use force against those directly responsible for the attacks, but also those who harbored them. So that's how we end up using force against Al-Qaeda and Taliban in Afghanistan. And then through lots of creative lawyering, sort of daisy chaining that out to many other groups and many other countries as well. And without an expiration date on that AUMF, we have seen that authority through successive administrations just expanded and expanded. So it's, who knows what is going to happen, but I think, as Linda was alluding to, this is a moment, especially with the withdrawal from Afghanistan, for the administration and for Congress to take a look not only at the existing authorities that are on the books, but also to reflect on future authorities and what types of limitations, sunsets, et cetera, need to be in place for such authorities, so we don't have this sort of endless expansion of those authorities.
I'm just thinking back to the trio of important Supreme Court decisions. I guess it was 2006. It was Justice O'Connor's opinion in the Hamdi case, where she took, the takeaway line from that decision, I believe, was a state of war is not a blank check for the president. Maybe one of the best, if not the only good line that came out of that particular period. But she also, the court, in her voice, also talked about the notion that detention was coexistent with military action. And the strong suggestion there, I can't quote the words, but that we could detain as long as there was a battlefield somewhere. The suggestion being that once there was no longer a battlefield, there could no longer be justification for detention. Now, of course, as you said, Rita, the battlefield can be defined as the worldwide effort against terrorism, I'm sure. But certainly the Supreme Court in 2006, those justices never envisioned that in 2021 we'd be sitting here and having this conversation. One thing that's greatly puzzled me is the holding of these individuals without charges at all. And would somebody like to speak to that? I think that's really unprecedented. It's one thing to be a POW under the Geneva Conventions and eventually get returned, that kind of thing. But these individuals have just been sitting there, right? And why and how? And how do we get out of that situation? Anybody?
I mean, I think part of the original plan was actually a far more robust use of the military commissions. I mean, if you actually go back and read President Bush's November 13th military order, which is a remarkable document that has been, I think, largely lost to history. Not lost in the sense that you can't just Google it, but lost in the sense that we no longer talk about it. I actually think that much of the plan was, interrogate the detainees to derive intelligence value, and then try them all for something. And I actually think that the piece that the government, I think the two big things the government failed to appreciate were, one, that they couldn't just use military commissions for whatever they wanted, that there actually was a body of law surrounding military commissions. Indeed, that the military lawyers, the JAG lawyers, would be instrumental in pushing back against such an abuse of the military commissions. But two, I mean, Linda, the thing about the 2004 trilogy, when I teach those cases, in my class, I mean, you talked about the Fred Korematsu amicus brief. What I will never forget about those cases is the CBS News story that broke the night of the oral arguments in Hamdi and Padilla. So Rasool's argued, I think, 8 days before Hamdi and Padilla, and Hamdi and Padilla argued on the same day. I think it was April 28th. And that night, CBS News breaks the story of torture at Abu Ghraib. Right after, I think it was, it might have been Justice Ginsburg. I don't remember which justice asked, but someone asked Paul Clement, does the United States torture? And Paul Clement said, no, we don't. And that night, Abu Ghraib breaks with photos all over mass media. The justices watch television, right? I mean, I have no doubt that when the history of this period is written, when we have access to the justices' papers, when all of us are long dead, that's going to be part of the story. And so I guess, Linda, what I think the government wasn't appreciating was, one, that the military commissions were not going to be a successful way of dealing with most of these detainees. And two, as soon as news got out about the coercive interrogations, about the torture, that was going to provoke a massive backlash, even from folks who might otherwise have been sympathetic to the project of detention, right? Even to the justices in Hamdi and Razul and Padilla. And I guess I just, to me, that's why the reckoning in 2005 isn't, to sort of come clean and start over. Why the reckoning at that point is to dig down, is to double down. Right, is to pass the Detainee Treatment Act, is to try to take away the Supreme Court's jurisdiction and then try again when the Supreme Court says you can't. Like, I'm almost as interested in that period. Like the initial decisions the Bush administration makes, fine, but like, why in 2005 is there this decision to double down? And frankly, why in 2009 does the Obama administration do what it did, right? The president's National Archives speech where he says, we're committed to the military commissions. I mean, that boggled my mind when it happened. And so I think, to me, part of the story, Linda, is not just what went wrong and what we failed to appreciate, but like all of the points of inflection along the way where I feel like the railroad could have been rerouted and where different actors at different times and for different reasons just let the train keep going.
I'm just Steve, to underscore what you said about the shock of the military order in November, setting up the military commissions. I think I'm right on this. Colin Powell, who was the Secretary of Defense at that time, wasn't told about it, learned about it in the news. It was all done around him by the political people in the White House and in Dick Cheney's office of vice president, and no sort of military intelligence, small I, was brought to bear on gaming out what was going to happen. I think somebody was trying to weigh in there.
Yeah, I was gonna go back to your question, Linda, about the indefinite detention, right? And I think it bears repeating that out of the 39 Muslim men who are still detained at Guantanamo, 27 have never been charged with a trial, 10 have been cleared for transfer or release, including some for years. So one of the things that needs to happen, and Rita was talking about, special envoy and so on, is that, one of the things that Obama did do was, after one of the inflection points was when the men facing indefinite, nothing available, took it upon themselves to go on hunger strike, which resulted in a crisis for the administration. And I think part of that crisis was self-caused, because 2009 and what came after was, it certainly looked like Obama bowing to maintenance of a military commission system in order not to have evidence of torture come out in the ways that we might have think it might come out in and should come out in federal court. But after hunger strikes and a recognition that the situation was unsustainable, remember that the Obama administration put in place the periodic review boards. And those are still an avenue. I think their standards are unfair, but they are still an avenue for resolution of, even with their threat-based standard for determining whether people should be detained. It is hard to see how men who have become aged, they're talking about hospice facilities at Guantanamo, why there wouldn't be a way of doing what the Obama administration did, which is wake up and press for resolution through the periodic review boards. A quick other thing, just looking at the 9/11 hearings that are going on now, the current judge was pulled out of the case before because he lacked the experience as a military judge to actually preside over commissions. And part of what we've never had or seen is people with the kind of experience that takes into account capital cases and capital prosecutors, because one of the things that happens there, which you don't need Congress to act, is a recognition that a way out of way forward through challenging issues is to seriously engage in plea bargains in a way that accounts for the needs of all involved. And here again, I'll come back to every single person facing charges in military commissions was subjected to torture in CIA black sites. There's no way to unravel torture from what's going to happen here. Because of the secrecy, that also means that 9/11 family members haven't been able to get the kind of transparency or sense of accountability that they themselves have been able to get. What happens often in federal cases, in capital cases, is that you can take the death penalty off the table and explore plea bargains that allow for resolution of this entire system and process. And I think that would be a good creative thing to explore and pursue, especially almost 20 years later.
Yeah. So of course, during those 20 years, the Supreme Court's become a great deal more conservative. We see what's doing in the Senate. It was proved impossible for President Obama to do what he wanted to do in the politics of that time. Let's not even mention the court. I think the court is out of this. This is really a political situation now, I think. Rita, is there anybody other than your boss who's sufficiently engaged with these issues to really move it to any place where it might possibly be productive?
Yeah, I mean, so one of the letters that I mentioned to President Biden was actually not from my boss alone. It was actually from 24 Democratic senators to the president, urging action to close Guantanamo and chart a new course here. So I think that there is plenty of support for looking at this rationally. I think the political challenges remain. There are those, of course, who will, try to use this quite sadly as a political football. And, we've talked about the harm to the victims and the families as this just drags on and on and on. And it's really a tragedy that 20 years later, this is what we are still looking at. The other piece that I wanted to mention was, as Hannah and Steve were talking too, is this sort of creative lawyering that we've seen. The other letter that Senator Durbin sent, that this one was to the Department of Justice, talks about the policymakers, executive branch lawyers, Department of Justice lawyers, and over the years, crafting legal positions that, if you really take a step back, and as you mentioned, Linda, right, you're like, this is the laws of war were not designed to be justifying detention for decades on end, right? If you're a prisoner of war, you can be held until the end of hostilities, but this is not the type of war that those rules were designed for, or that the court had in mind. But it's this creative lawyering that's really, just fixated on these really specific questions to try to justify all sorts of things that on their face, if you take a step back, seem a little bit ridiculous. So we've, this creative lawyering has been used, as we, he talked about in the letter, to rationalize indefinite detention for now 2 decades, without charge or trial, without, as others have mentioned, without there even being a resolution of the question of whether they get basic due process. It's been used to justify the detention of individuals as enemy combatants who were not even alleged to have taken up arms against us. Creative lawyering has been used to deny basic protections, including, to fight habeas petitions for people who are elderly, ill, and of people who are actually already approved by the administration for transfer. Lawyers are still arguing that those individuals can be detained. So this is really a moment to take a step back from that, like all the fancy legal mumbo jumbo, and look at what we're really talking about here, which is holding human beings for 20 years and denying the victims and their family members any semblance of justice.
A couple interesting questions have come in the chat, and let me read both of them and then just toss them out to people, because we we'll be running out of time pretty soon. So one question is a plea bargain enforceable after duress like this? 20 years of detention without trial and threat of more detention. So I guess the question being, can a plea bargain really be thought to be voluntary and informed under these circumstances? And the second question, does anyone agree with me that under cases like Zivotofsky, the president could bring the prisoners to the US because the limits imposed by Congress are an unconstitutional limit on his powers? Besides, who would have standing to object, assuming they could get to court before Biden, quote, evacuated 39 detainees? Zivotofsky, if I remember the case, was the case about whether Congress could force the State Department to recognize Jerusalem as the capital of Israel on a passport issued to an American citizen who happened to have been born in Jerusalem. And the State Department, for diplomatic reasons, resisted this. And I guess the court said, as a matter of separation of powers, the State Department had the last word. So I'll throw those two questions out: plea bargain and presidential power, to whoever would like to tackle those.
Well, I assume Steve is chomping at the Zivotofsky bit. Let me just maybe address the plea bargain question. It's a great question in theory, but I mean, we're talking about Guantanamo, and which is so sort of extra legal and so laden with coercion. In the ordinary course, you would think this would be a fair argument, but I don't think there would be any sort of legal challenge to an otherwise agreed upon plea bargain, despite being laden with torture and a threat of ultimate indefinite detention. And I do want to sort of address your question, Linda, of how we got here, that you can have someone detained for 20 years without charge. Indeed, in the Hamdi decision, Justice O'Connor said, incident to the use of force is, which is authorized by the AUMF, is the power to detain to prevent a return from the battlefield. And she anticipated an argument, well, that could mean detention for up to 20 years. And in her inimitable, as you well know, way, as with affirmative action, she said, well, we can get to that when we get to it. And in the meantime, if not in the Supreme Court, but the lower courts, the detention power and the set of rationales by which one can be detained seems unlimited. It was in court maybe 3 years ago where the government defended detention under 100 Years' War analogy, and with the remotest association. So, we're really, so it's sort of a heads I win, tails you lose shift from law to maybe not fiction, but at least power. And I, just one last thing, I'll turn it over. I mean, I think you mentioned the Korematsu amicus brief, and it reminded me that, the general strategy in 2004 around these cases was not to pit terrorist suspects, the rights of terrorist suspects against national security, but to have a narrative about the rule of law and to suggest that Guantanamo was exceptional. And in creating this kind of a system, America had somehow lost its way. And, I think that's an attractive narrative, but I think we have to reconcile with the possibility that maybe Guantanamo is not so exceptional. If you think about the jurisprudence around the death penalty, or our phenomenal penchant for solitary confinement, and the massive carceral state that, wildly disproportionately imprisons Black and Latino people, maybe there are some features of this in our DNA need to be thinking about Guantanamo not as exceptional, but in dialogue with the other forms of, policing and prisons that America seems pretty addicted to.
Yeah, it's really a window on us.
Yeah.
On the Zivotofsky question, I mean, I realize this is a little more technical and perhaps less interesting than what Bahar just said. I think an argument can be made that the transfer restrictions interfere with the president's constitutional authority. I certainly think that argument was available, especially with regard to, say, the Bo Bergdahl swap, president was doing a POW exchange in the middle of a war. That's not the kind of thing Congress typically handles. The problem here is that those arguments are arguments that President Obama was allergic to making, and that I suspect President Biden will also be allergic to making. They are based on, Linda, theories of executive power that I think for good reason, Democrats have been very reluctant to embrace. And I don't think Zivotofsky helps because, Zivotofsky is such an outward-looking case where the question is about diplomatic recognition of a foreign sovereign, whereas defying the transfer restrictions would literally mean bringing the detainees into the United States in a context in which, even I would have to say Congress has some role to play. So, I think defiance is an option, but I think, if the Biden administration's not willing to spend the political capital on AUMF reform, it's hard to imagine that they would spend the political capital on an outright defiance of the transfer restrictions, especially when all that solves, right, is, Ben Wittes and I used to have this fight. Is closing Guantanamo about closing the prison or ending the policy? And I don't know that the Obama administration ever had a coherent answer to that question, and I'm not sure the Biden administration does either.
Well, as we wrap up here, unless anybody else has anything they'd like to wrap up with, it just occurs to me to say, we've never gotten out of the black hole. We kidded ourselves for a few short years when the Supreme Court was exercising its authority in a positive direction, that we had climbed out of the black hole. But I think from what all of you have used your expertise to tell us, we're still in it. If anybody disagrees with me, please say so. We have, I think, 1 minute left. But if not, let me thank all of you and Russ Feingold and Deborah Perlin for putting this panel